All right, KSLU law students, settle down and get your bare axe ready. Today, we are dissecting an absolute cornerstone of property law. We are looking at a classic examination question. Explain modes of determination of lease and the doctrine of holding over. Now, I am reading this verbatim because you absolutely must understand the weight of these words. This lecture is going to be your ultimate, foolproof blueprint for securing a full 16-mark answer in your upcoming university exams. So pay very close attention. What we're covering today is not just some dry academic theory. It's the strict legal mechanics that our courts rely upon every single day.
Here is your roadmap for today's lecture. 1. Introduction to lease termination. 2. Section 111, determination modes. 3. Section 116, holding over. 4. Distinguishing tenancy at sufferance. 5. Landmark case law analysis. And 6. Conclusion for maximum marks. Let's get straight into it.
Section 1, Introduction to the Termination of a Lease. Before we jump into the specific points, let's get the fundamental premise straight. A lease does not continue indefinitely. It must end or be determined in several specific ways. These modes of determination are strictly laid down in Section 111, and the doctrine of holding over is found in Section 116 of the Transfer of Property Act 1882. By firmly anchoring your answer in these specific sections, you instantly tell the evaluator you know exactly where the statute governs this right. Okay, let's look at Part 1, Modes of Determination of Lease under Section 111. Number 1, by Efflux of Time under Section 111A. This ends automatically after the expiry of a fixed term. For example, a lease for 5 years ends exactly after 5 years. Number 2, by happening of specified event under Section 111B. This ends on the occurrence of a specified condition. Example, a lease till the completion of construction. Students, I want you to memorize these statutory headings and these specific illustrations without skipping a single one. Efflux of time literally just means the clock has run out. If your contract says 5 years, on the exact expiration of that 5th year, the lease determines automatically. No separate notice is required. For Clause B, the happening of a specified event, well, the lease is conditional. Once that construction is complete, boom, the lease terminates instantly. Write these exact examples in your paper to prove your conceptual clarity to the examiner.
Continuing our strict breakdown of Section 111. Number 3, by merger, Section 111D, which is when the lessor and lessee become the same person. Number 4, by express surrender, Section 111E, which is a mutual agreement to end the lease. Number 5, by implied surrender, Section 111F, which is conduct inconsistent with continuation. An example of this is accepting a new lease. Now let's deliberately dissect the legal mechanics of merger here. Under Section 111D, if a tenant actually purchases the very house they're renting, a larger estate, the ownership, and a smaller estate, the lease, merge in the very same individual. The lease is swallowed up. It is entirely determined. Also take note of the vital difference between express and implied surrender. Express surrender is a formal, documented mutual agreement to basically tear up the lease. Implied surrender, however, happens purely by action. If a tenant, right in the middle of their current lease, legally accepts a brand new lease for the exact same property from the landlord, their conduct is entirely inconsistent with the old lease continuing, right? So the law automatically implies a surrender of that old lease. Now, pay your utmost attention to these final modes. Number 6, by forfeiture, Section 111G. This occurs due to a breach of express condition, denial of the lessor's title, or insolvency. And mark my words, it requires notice. Number 7, by expiry of notice to quit, Section 111H, terminated by proper notice. And number 8, by death, if the lease depends on personal qualification. I really need to hammer home an absolutely crucial point regarding forfeiture under Section 111G. Forfeiture strictly, and I mean absolutely, requires a notice in writing to the lessee of the lessor's intention to determine the lease. If a tenant denies the landlord's title, let's say they start running around saying, I am the owner now, the landlord cannot just throw them out that very second. Notice is a strict statutory prerequisite. I'm warning you right now, missing this specific detail about the notice requirement in your exam script will cost you heavy marks.
Moving on to Part 2, the doctrine of holding over under Section 116.
Let's read this definition very deliberately. Meaning of holding over. When a lessee continues in possession after expiry of lease and the lessor accepts rent or assents, a new lease is created. Listen to me, I instruct you right now to mentally underline the phrase accepts rent or assents. Better yet, when you write this on your exam script, literally underline it with your pen. It is the absolute crux of the entire doctrine.
Merely sitting in the property after the lease expires is not holding over. The legal magic only happens when the landlord doesn't act, like formally accepting rent or actively giving assent that clearly signals their agreement to the tenant's continued possession. Let's walk through the essentials of this doctrine chronologically. Number 1, the lease must have expired. Number 2, the lessee continues in possession. Number 3, the lessor accepts rent or gives consent. And number 4, a new tenancy arises, which is either monthly or yearly. These 4 conditions absolutely must act sequentially to legally establish holding over. You simply can't have holding over if the lease is still active. So step 1 is expiration. Step 2 is the physical reality. The lessee stubbornly stays put. Step 3 is the legal trigger. The lessor accepts rent. And finally, step 4 is the legal consequence. A brand new tenancy arises. Depending on the purpose of the original lease, it becomes a month-to-month or year-to-year tenancy. I want you to write these points in a vertical, numbered list just like this on your exam.
Observe these points closely. 4. Nature of holding over. It creates a new tenancy based on implied agreement, and it is not a trespasser. And 6. Illustrations. Illustration 1. Lease expires, landlord accepts rent. That equals a new tenancy, which is holding over. Illustration 2. Tenant continues without landlord consent. That equals a tenant at sufferance. Let me explicitly explain how the legal nature of the doctrine directly informs these 2 distinct illustrations. You see, holding over is rooted in consensus ad idem, a meeting of minds. It is an implied agreement. Because the landlord accepted the rent, the tenant is emphatically not a trespasser. That is exactly what illustration 1 shows us. But look at illustration 2. If the tenant stays and the landlord does not consent, there is no implied agreement whatsoever. The law firmly labels this precarious position as a tenant at sufferance. I sternly command you to physically draw this exact high contrast table in your answer booklet. Distinction: holding over versus tenant at sufferance. On the basis of consent, holding over is with the landlord's consent. Tenant at sufferance is without consent. On the basis of status, holding over makes one a lawful tenant. Tenant at sufferance makes one an unlawful occupant. On the basis of a new lease, holding over? Yes, a new lease is created. Tenant at sufferance? No. Now listen, evaluators have hundreds of scripts to correct. When they flip the page and see a neatly drawn table that instantly distinguishes a lawful tenant holding over from an unlawful occupant at sufferance, it practically guarantees a higher band of marks. It proves your analytical rigor at a single glance.
Section 7. Case laws, the judicial pronouncements. Judicial precedents are the absolute anchor of any legal argument. You cannot claim to understand the Transfer of Property Act without knowing how the Supreme Court and federal court have interpreted it. I want you to write this first case law in a separate boxed format in your exam. Bhavanji Lakamshi the Himatlal Jamna Das Dani. Our text notes that this case explained doctrine of holding over and acceptance of rent. Let's expand on exactly why this is strictly relevant. The brief background of this landmark case involves a tenant whose lease had expired, yet they continued to tender rent. The landlord technically received this money, but claimed it was merely damages for use and occupation, definitely not rent to create a new lease. The Supreme Court's ratio decidendi here was profound. Mere acceptance of rent is not, by itself, absolute proof of assent. The court firmly held that to establish holding over under Section 116, there must be a clear, bilateral intention on the part of the landlord to create a fresh tenancy. The relevance of this case is absolute. It teaches you that acceptance of rent in the bare act implies a conscious, mutual consent, not just the mechanical cashing of a check. Next, you need to underline this exact citation to immediately capture the KSLU evaluator's attention for a full 16-mark answer. Kai Kushru Bazanji Kapadia, the Bai Jerbai Herjaboy Warden. Our literature clearly states this case clarified distinction between holding over and tenancy at sufferance. Let's break it down comprehensively. In this federal court case, the tenant stayed after the lease ended and just kept sending rent checks. The landlords retained the checks but purposefully delayed cashing them, attempting to figure out their legal standing. The verdict delivered a razor-sharp distinction. A tenant continuing in possession without the active, demonstrable consent of the landlord is merely a tenant at sufferance, a legal status just one step above a trespasser. It is only when the landlord performs an unequivocal act of assent, like officially cashing that check explicitly as rent, that the unlawful sufferance transforms into a lawful holding over. This is the definitive precedent distinguishing the 2 core concepts.
We'll now conclude this lecture by reading the final text strictly. Conclusion. A lease can be terminated in various statutory ways under Section 111. However, through holding over, a new tenancy may arise, ensuring continuity based on consent and conduct of parties. Writing this exact conclusion provides a robust, professional finish to your paper. It perfectly balances the strict determination of a lease against the equitable continuity provided by the doctrine of holding over. It shows the examiner you understand the complete life cycle of a leasehold property, absolutely securing those maximum marks.
I'll leave you with this final thought. Are you prepared to accurately identify the precise moment a tenant transitions from lawful holding over to an unlawful tenant at sufferance in a live courtroom scenario? Remember, passing the examination is merely step one. True legal acumen requires you to continue mastering the bare acts so that when a client finally sits across from your desk, you know exactly when the clock ran out and exactly when a new tenancy was born. Study hard, review these sections thoroughly, and I will see you in the next lecture.